So today we find myself in company of the Honourable Margaret Beazley, Governor-General of New South Wales, and in a former life, a leading lawyer and participant in the Commonwealth Lawyers Conference in Livingstone, Zambia. Your Excellency, it's lovely to see you, my morning, your evening, and the last time we saw you, you were in Livingstone, Zambia. Do you have any recollections of that conference and that experience?
Well, given at my age, Brian, it's not so long ago that I wouldn't remember it. But because we are speaking to lawyers and accuracy is very important. Here in New South Wales, I'm governor, not the Governor-General. The Governor-General is the Governor-General of Australia. Mm-hmm. But for us, at the constitutional level, that means that simply means that he has a bigger jurisdiction out of the whole of Australia. But in Australia, we have each state governor has a direct relationship with the Queen herself. Yes. And just as the Governor-General has a direct relationship with the Queen herself. So even though the Governor-General bears that title, he doesn't actually have any hierarchy of the state governors. So Governor of New South Wales, very happy for that. And
I see.
Lovely to be here.
And you took up that role pretty well immediately after you returned to Australia from Livingstone.
Pretty much. I think we then went from Livingstone, we went to India, to Jindal University there for a week, and back home, and I think it was about 4 days, and it was on the job, and it's been a very busy job.
Yes, of course, I'm sure it has been affected by the coronavirus and the pandemic, and many of the functions and entertaining are no longer possible. And how have you been managing in the present emergency?
Well, it's been very interesting. We always like to describe the role of the governor, and this goes also for the role of the Governor-General, as having three aspects: constitutional, which is our meeting with the Executive Council in New South Wales. We do it every week, and I sign legislation which has been passed by the Parliament. It's a time when I can have a discussion about the legislation that's going through if I wish to have it. But I, of course, have to act on the advice of the ministers at the end of the day, just as the Queen acts on the advice of the ministers in England. So that is still ongoing. The ministers still come to Government House. But we have a legislation which permits the Executive Council to be conducted with a quorum of 2 ministers. So it's not as though I have to have a whole ministry down here. And so that works very easily. We have actually, one of the things I did sign off on recently was a regulation whereby we could have these Executive Council meetings, just as you and I are having a meeting now, could have them online. At this stage, the ministers have chosen not to engage in that part of the process. I think they rather like the person-to-person engagement after we do the formal part of the meeting. We usually then have a broader discussion around issues that are affecting the state.
You're mentioning, Your Excellency, the use of technology, and of course in a former life you were a judge and a leading lawyer. Did you ever experience the use of technology then, and do you have any observations to make or concerns about the use of technology for conducting trials now?
Look, just talking about technology, I'll just make this one comment about how we're using it now in my role. I mentioned that I can actually perform the constitutional role by using technology. An extraordinarily large part in terms of time of the role of governor is a community aspect. And we travel around the state. We visit an enormous number of organisations, speak to an enormous number of people. Now, we can't do any of that. And so what we are doing is getting all of those organisations online, and we're in effect having a virtual engagement with them, which is good enough, but not as satisfactory as actually being on the ground with people. There's much the interaction is easier, of course, from person to person. You don't have time delays. Sometimes you don't have the static and things like that. Let me transfer that back into the court situation. I have been involved on a couple of occasions in what they called electronic appeals, which were started to be trialled in New South Wales. But they were not, again, very successful. They were really a matter of having real-time transcript, being able to edit the real-time transcript as you went along, things of that nature, that you could bring documents up on screen. That can be very useful, as you know, in a large case, a large document case, where instead of everybody, for example, if you're in a case which involves large pieces or parcels of land and there's a map involved, you can, I'm sure you've had this experience. So whereabouts on the map are you looking? Where should I go? Down to the left? Or is it up to the right? Whereas if you have it up on a screen, of course, you can have a pointer and everybody can be in the same place. So there are huge advantages in the use of technology in that much simpler scenario. Of course, I haven't had to use technology in the type of crisis situation we have at the moment, but I still speak to my former colleagues and my good friends in the courts, and I also speak to barristers. I think my sense of what has been happening here in New South Wales, bearing in mind that barristers can go to court because that's a workplace, but the entire community is being encouraged to work at home if they can, rather than sort of being out and about. Now, and there we have social distancing rules where they're supposed to be 1.5 metres apart from the nearest person. Every person is supposed to have 4 square metres of space in which to stand or sit and not be closed in by other people. So there are real restrictions, and you can imagine where that might go with jury trials, which in effect have been suspended. How has the technology gone, and how the trials been running? It's very much a question of the effectiveness of the technology. The New South Wales government responded very quickly to upgrade the technology in the courts. As the Chief Judge of the District Court said to me, he was able to achieve in 3 weeks what he might not have got out of the government in 5 years otherwise.
Really?
Yes, so that has been a huge uplift, but the District Court that I just mentioned, it has a civil and a criminal jurisdiction. The criminal jurisdiction is predominantly jury trials, although you can have a judge trial alone. There was one jury trial which had to finish as it ran over the restrictions, and they managed that. They managed it very well in the circumstances, so not to lose a 2-month trial and have to start again, by having the jurors placed around the courtroom at 1.5 metre intervals.
Mm-hmm.
It worked, but it's not the way you would normally wish it to happen. The judges say we're managing, but some days the technology seems to work very well, some days it falls out. That often depends on the, I think the expertise, if I can put it that way, or the facility that the legal practitioners have using the technology more often than not from their home base. And sometimes it's all about bandwidth. And if everybody, if every court in New South Wales starts at 10 a.m, suddenly, if everyone's come in, so they started to have staggered court hours and things of that nature. So I think it was a very responsible response to a crisis, and it is a crisis. These measures were introduced so as to avert a problem down the line, because if you just stop the courts, then it doesn't take long for lists to, we use the expression here in Australia, blow out, that is, cases to sort of accumulate in the list. And that's already a problem in the justice system, I think, around the world, but here in New South Wales as well.
I think the the sort of build-up of pressure on the courts if no work is being done, or very limited work only for emergency cases. There is going to be almost a pent-up demand. We were talking the other day when I was on with your husband, Your Excellency, about an observation that you had made about the absence of, if you like, the public entitlement to come into courts. Do you want to share those thoughts with me?
Yes, I think that is something that I suspect was not well thought through in the immediate response to the COVID crisis. I think the immediate response was, we really have to keep the courts functioning, otherwise we will have a significant problem. And one doesn't know when restrictions are going to be lifted. We've been very fortunate here in New South Wales to, in Australia really, to have a significantly limited number of cases. Too many, but limited. But just to give you an idea, I think here in this state, New South Wales, the largest state in Australia with a population of about 8 million, we've had 3,000 odd, just over 3,000, 3,100 or something, confirmed cases. We've had 46 deaths. In the last 3 or 4 weeks, we have been having new cases only of anywhere between 3 and 12 new cases a day. And increasingly in all of those, I think we've been able to trace the source of them. So we're doing well. So we may be able to come out of real restrictions perhaps in 3 months, one doesn't know. But when the lockdown happened and everyone was hit by the COVID crisis, we didn't know, no one knew whether this was going to be a 12-month aspect of our life, and everyone was going to be isolated or semi-isolated for that period of time. So you can't let a court system not operate for 12 months. However, even though the videoing is going on in court, in some cases, some judges were doing it from home, but one judge said, "Oh, we're doing this, it's wonderful." And I raised the question of access to justice, and the judge responded, "Oh, but we have a journalist in court, and we were entitled, we consider a journalist to be a member of the public." I said, "But the journalist was in court because that's a place of work for the journalist on that particular occasion, and you're allowed to go to a place of work. Other people were not the public who might be interested to be able to walk into the courtroom at any time and see the way justice is being administered, were not able to because of the lockdown restrictions in only being able to go out for essential things." And I must say that is not something that court had thought through. I raised it with the Chief Justice of another court, and his response was, "Oh, well, we can manage that by, in effect, by live streaming." But again, neither that court nor many of our courts here in Australia do live streaming. And I think that's probably pretty much a universal problem in Commonwealth countries.
Yes, just on that point, interestingly, of course, the Supreme Court in the United Kingdom has experience of live streaming, and to that extent, it was maybe ahead of the game in terms of setting that up. But it's very hard to introduce it instantly, and there does need to be, of course, the technology and cameras and the general infrastructure to make it work. So I do find that a very interesting point about the access to justice has as an important element literally the availability of the public being able to see justice being dispensed.
I think it's a very important topic because so many people, including members of the legal profession and some judges, are saying, "Oh, well, we'll never fully go back to what they call the old way, of everybody having to turn up to court and the like." So it is something that needs to really be at the forefront of everyone's mind. A number of the judges who run lists have said, "Oh, well, in the future, our lists, the applications lists and the call over lists and things of that nature, they'll all be done online in the future. That might be an efficient way to do things, but the same question arises: at what point do you say access to justice and the openness of the court, sort of go hand in hand, and at what level should they drop off? I think the other point with access to justice is this. It's one thing to talk about the large commercial cases where there is, the money and the technological support behind the scenes, which enables these cases to go on. And there's much more experience with taking evidence from overseas, etc., in those types of cases. But even though they may be a great proportion of the cases that are heard in terms of quantum of damages or issues involved, they are not the great proportion of cases that are conducted throughout the courts in the state. And so you'll have many practitioners who won't have either access to or the facility to deal with good technology. And technology, these days it's quite well matched, but not always. But you have to have the good technology, not everyone has it. But what about the plaintiffs or the applicants? What about the defendants or the respondents if you don't have those in court? And it's a long way from assuming that those persons, and they're the persons about whom justice is all about, if they're not the ones who are able to be in a position where their case is being heard, anyone can see how they're being dealt with in a courtroom, anyone can see the process and get a sense of whether it's fair or not fair. So I think these things really do warrant very deep consideration overall. I think there could be just one other aspect too, is you see it, for example, with stories about newsreaders, etc., who put on their very best tie, and I have to say that's a very smart tie that you're wearing, Brian, at the moment. But they often have a pair of shorts on.
Yes.
And I do know of one judge in New South Wales, who refused to continue with an online hearing because the barrister had put on her robe, but she had a t-shirt underneath. And there is that tendency that unless it's the formality of the situation being pressed upon you, that there is a tendency to the informality. And once you have the informality, it's a different process.
Yes, I do think it's a very helpful observation. The drift towards informality and the respect of the office and the, if you like, the majesty of the law can be lost in circumstances where people are themselves in a very informal circumstance. Well, Your Excellency, I appreciate that your time is short. We certainly, I have enjoyed once again a conversation with you. You have raised some very important aspects of access to justice in terms of the public access, the limitations of technology, and the slide towards unhelpful informality. I appreciate very much your time, and I'm sure the members of the Commonwealth Lawyers Association will both appreciate your contributions to the CLC in Livingston, and will join me in once again congratulating you on your position in New South Wales as Governor. And thank you very much indeed for sharing those thoughts and your time with us this morning. It is hugely appreciated.
Thank you, Brian. And can I say that this is a very important organisation. It's deserving of the very good leadership that it has and has had. And I think that the connection of this organisation with the Commonwealth generally and what that can do to support and promote the rule of law is very important. So congratulations and well done.
Thank you. Thank you very much. We'll stop now.